Test. Mic 2. Mic 1. Test, test. Mic 2. Test. Okay.
Good afternoon and welcome to another session of Real Estate School with Soma. Today we've got a very interesting topic about contract and what are the red flags that can kill your deal. Today we've got a very interesting topic about contract and what are the red flags that can kill your deal. Sorry, I have some technical problem which I just adjusted. So anyway, as I said, today's topic is quite interesting. Red flags, red flags that can kill your deal. So we've got a very interesting speaker. Of course, I introduced him, but before that, I've got a couple of announcements about what's happening in the profession. The first announcement is that RRP classes. REN renewal program. Please take note, RENs, that you need to go and attend your classes. If not, you cannot renew your tax next year. I've seen so many negotiators coming back to do the NCC classes, and they have to pay extra money. They have to now have to pass this certificate and all that stuff. So it's very important that you do the classes so that you can renew your tax. Don't worry whether you want to continue doing or not, but just renew your tax. Okay, that's most important. So your classes will be up to December, I'm told. But I know that last year they stopped the class. They stopped the class. In October. So don't wait to the last minute. Please go and attend the classes. The other important point that I wanted to mention is that the renewal will start from January, as you know, but they may open the renewal earlier. That means either October, November, December. We're waiting for circular. So submit early so that you can get your tax early. The other important note that I want to make is that a lot of negotiators are out there without the rent tax because they're waiting for the renewal. One is for the renewal. Second one is all those who went for the NCC classes. So it's important for you to note that there is a delay. I've got friends coming from Johor and other states all tell me they're waiting for 2 months, so 3 months. So I know that you're having difficulty because of rent tax, you can't advertise, but just be patient because the board has got an issue with their new BI board information system. They revamped it and they're having some difficulties, so they are troubleshooting it. Once they have done it, you'll be able to get your tax. So be patient, but keep checking the board's website under search whether your rent tax has been approved. If it's been approved, then you can immediately go and advertise, even though the tax will take a little bit longer to come. Okay, so that's the situation. And the last announcement is there was a confusion about the 100 ringgit that you have to pay for the tax renewal. Now, please remember this: if you have gone for NCC classes, let's say your rent tax expired, you're going for NCC classes, you do not, I repeat, you do not have to pay RM 100 ringgit. I have been made to understand, and I know of the fact that a lot of people have paid 100 ringgit extra to renew your tax. Now, the confusion arose because when you did not renew your tax by March this year, for the 2026, so what happened was there was a penalty of 100 ringgit to get a new tax. So that was a 100 ringgit. Or if you're in another firm, if you change firm, you have to pay 100 ringgit. But if you're attending NCC, whether you are new or you are a existing REN expired, you do not have to pay a 100 ringgit. Okay, I know, I believe hundreds of people have done this. We got this clarified for the board, and so you don't have to pay for that. So just that clarification. Okay, let me now introduce the speaker for the day. Ananda, can you join us?
Thank you. Thank you so much, Mr.
Welcome, welcome. Come, please sit down. So there's a change. All the time, we have got very senior lawyers sitting here. This time I thought it's good to get a fresh face because a lot of RENs, young RENs are out there perspective from a younger lawyer may be something that you can agree, or you may be able to follow through. So today, Ananda is going to talk about the subject matter of contracts and what are the red flags that can kill your deal. He is a very experienced conveyancing lawyer. I don't want to say too much because it's all on the slide.
Yeah.
He's attached to Adha, Selvi, and associates. Of course, we don't have to say any qualification because everybody will have to. He's qualified from England. By the way, I also heard, I read in your CV that what you were leading.
The guild.
Guild, what is that?
It's like a students' union.
Ah.
So even there, one of the big issues we were working on was tenancy and tenancy rights and all this. So even there, they have the same problems. What we realize is the maybe property agents or most likely landlords, the big landlords, were copying the same problematic terms in the UK, using it here, and now the courts have caught on to it and asking to change. So the same issue 10 years ago, we brought it here, Malaysia, we imported it a bit delayed. That's why.
Okay. So is there anything interesting about your career you want to just say?
We've done a few. I've been lucky enough to do a few things, one of which was working with MIEA, working with some of the property agents here on revamping contracts, especially on the offer to purchase and appointment letters. And I'm sure we'll come on to it shortly, but you'll be surprised at how many experienced RENs and REAs are still making the same mistakes because they're using the old format. Like we'll talk about the SST and all this. And I think those are some of the things that people can improve on, that we will avoid problems.
We will come to that. We'll come to that. So Ananda's company also legal advisors to the Malaysian estate agents for many years now. So he knows what's happening in the real estate profession, and he has attended our AGM. He knows all the hoo-ha that is going on in the profession. So it's quite familiar. And very interestingly, the office is situated just a few floors below the Board of Valuers office, in Wisma UOA. Okay, let's go into the questions that I have prepared. Okay. So from your experience, what are the most common red flags in a sales and purchase agreement that agents often overlook but can completely derail a deal?
Okay, so for the first one, regarding what are the biggest red flags, there's actually two. One from the agent's perspective, one from the parties who are involved perspective. So in terms of the party involved, let's take simple ones. Tenancy, no tenancy. All of us think, hey, very simple. What if there's a tenancy? It should include the sales coming with tenancy. If the tenant is leaving, ask me, no tenancy, by the time it's over. But there was some. We had one recent case, it's about 6 months ago. On viewing the property, there was a tenant there. Now, buyer is coming in thinking this is a property I want to invest in, let the tenant run, pay the mortgage from the tenancy. Common. Agent pitched it as tenant is going to be here at least 1-2 years. Don't worry about this, blah, blah, blah. In the offer to purchase comes with tenancy, but doesn't have a duration. It was a consent property, if I'm not mistaken. Yes, consent property. So it took a bit of time. At the end of the consent, okay, sign everything, give the keys. The tenant comes up to the buyer and says, my tenancy is up in 1 week. Sekian terima kasih, I'm going. And he's like, hey, it's with tenancy. What you told me is with tenancy. When check with the agent said, no lah, this guy will finish only in December of the year. Don't worry, da. Tenant left. Tenancy agreement was there. It says it's only until June. So now the agent is on the hook. Because he went and he, like a hero, came and said, yes, the tenancy will be there. Ding dong, luckily settled amicably. But that small change they could have done is just get the copy of the tenancy agreement. Have a look when it's finishing and then tell the buyer. Would have saved everyone so much time.
So, but this case just settled.
We said lucky it was settled.
Okay.
Yes.
What happens in because this is something our agents don't see.
Yeah.
What happens now if, let's say, the buyer wants to take legal action against, in this case, is the rent. It's not the landlord. It's not the owner. What can really happen?
So it depends on the extent of the representation. So because you see, at the end of the day, the REN is an agent of the vendor. on black and white, in that case, the SPA very clear. It came with tenancy, but it didn't say how long. So the how long, that particular period, the buyer was relying on what the REN said. So the REN is saying at least for another 6 months is there. In theory, they would have to compensate that 6 months out of the REN's pocket. And lucky that's not too big a tenancy. I'm sure they could have afforded something. But that whole thing could have been so easily avoided. What was surprising is all it took was, hey, can I get the copy of tenancy? Job done. That whole problem would have been removed. Another one we had where the tenancy was at the start. This is before the SPA is signed. Thank God the lawyer in that case had checked on the tenancy. And they said, hey, no, it's finishing before time. Buyer pulled out. Because the whole reason for buying that property was as an investment. No tenancy, no, I'm not going to go and waste my time to search all this. Pulled out.
So, so you would call that statement he made, would it be a misleading statement or a misrepresentation?
That is misrepresentation because they are represented as part of the sale.
So, ladies and gentlemen, this is what we should be very aware. Sometimes we really don't go into the depth of the issue. We all think that it's so easy, and then after so many months of hard work, you get into trouble. This is something which a lot of agents and rents, maybe the agents are aware, the rents might not be. This is I am of the opinion that there are hundreds and hundreds of cases out there where agents have really misrepresented, misleading, or they made mistake. In your view, having dealt with rents and agencies and clients, is this an alarming rate, or it's okay, nothing to worry, or it is of significant? It has a significant effect on the profession.
Okay, I think for that question, there's three parts. Does it have a significant effect? Yes. Let's not go too far into, is it the statistics alarming, increasing? I cannot speak to that. But what I can say is this. For certain cases, a 2-minute check would have saved 6 months down the line of you hassling, going to Bovia, going to having talk with the agency, paying the lawyers, or paying the consultants to write the response. All that could have been avoided, number one. Number two, do I see a lot of it? Unfortunately, although I may be young, short career comparative to a lot of other people, I've seen my fair share. And some of it are very basic that because of experience, sometimes they just forget to check or forget to look into. Like a very simple one that we had was, forgot to put in whether the person was deceased property, forgot to put deceased name. They just said the buyer is this one of the sons, never checked anything, sale cannot go through, which I'm sure we'll talk about more on that. Does it disrepute the profession? Yes, of course, because a lot of these buyers, a lot of especially first-time buyers, you'll be surprised at how much trust they have on the agent. They don't even trust the lawyer. Let's not talk about that. They trust the agent, the negotiator more, because that's their first port of call. The way that the negotiator brings them through the house, say, look, this is what you're buying, all this thing. That trust, it's very hard. Once it's broken, they have lots of things to say, and they are the worst ones to go complain here, put on Facebook, do all the other things. Same goes with vendors, especially older vendors. Maybe this is their second sale, third sale. They have certain expectations of a REN or of an agent. And if it is not met, they are the first ones to be able to tell you, hey, this is not done correctly. I want this, I want that. And an agent has to know what is their duty versus what is just appeasing the client. So those little navigational tricks. So I've seen a lot more complaints on standards. I've not seen in terms of like, oh, they've done something so horrible that, worthy of being, disciplinary action, all this.
Okay, all right. So what other early warning signs do you have? Maybe if you can go through a couple of them quickly.
Okay, first one, simple one, I know you will be surprised. No copy of title. The moment the vendor says, I got no copy of title for a title property, something must flag, something must be wrong. Because they would have a copy somewhere, or maybe they know their lawyer or their financier to have. If they don't have, something not right, especially with scam cases. Deceased property, like what we mentioned, quick check, see whether the name, who is selling. The vendor being selling, or the vendor saying, I'm the husband or I'm the wife, check and see betul ke tidak. There's a lot of scam cases going on. That small check saves the deal. And last one, this one is my favorite, property address. They don't check 2A versus number 4 versus 13A and all this. That small check, they don't check on the listing also. On the listing, they put the property as per as their driving Google Maps one. But that's not what you're selling, because end of the day, when it comes to the sale, the agreement, we're following the assessment, or we're following the title. That's not there. And it ends up being something. We've had one case, section 1, being something else. And I was like, how could you not check this address, what you're selling?
Simple thing, but the simple things are the easiest thing
to forget,
and
yeah.
to do. Yeah. Okay. So let's go to the second question. Incomplete and vague terms. How dangerous is it when the contract terms such as vacant possession, date, fixtures and fittings, or payment schedule are vaguely drafted? Can this lead to disputes?
Yes. Let's start with the payment schedule, the most
Okay.
dangerous one. A lot of deals these days, especially the PJ area, were $1 million deals. Some buyers need a bit more time. So they maybe, instead of the usual 3+1, they go 6+3 or 12+1 or 12+3. So be it. When they have those particular terms, it's very important to check how much is the deposit, how much is the installments, some SPAs have, as well as how much the final financier is paying. These terms, if they're not written black and white, or they have certain dispute, that is the one that gets referred to court. The deal doesn't go through. Ends up being either the purchaser is suing to compel the sale, or the vendor is saying, I want to abort and forfeit the fees. And at that part, has to do with how many months, how much to pay at month 1, month 2. Those small things, very important. And this can be done actually at the offer to purchase stage. Okay, we're going at 3+1. That's the first one. The second one, which was to do with vacant possession or legal possession, this part, that's where the tenancy, like what we talked about, comes into play. Now, vacant possession to me is very important if you know the buyer wants to move in.
Okay.
I know it's a simple thing, but most agents may not. Once the OTP signed, I've done my part, get the SPA signed, fantastic. But if they want to move in, that's where they'll raise all hell. Whether there is vacant possession at the time of the 3-month, 4-month, will it be there? Very important. If not, it gets referred. And the final one was fixtures and fittings. Oh, this one is a fantastic one. $1.2 million deal fell through because of fixtures and fittings. It's a commercial property, Mon Kiara. Simple. Agent came and said, fixtures and fittings included, like a hero. Vendor said, whatever is there that is not the tenants, I will sell together. Very important, he said, is not the tenants. Tenant brought in the aircon, tenant brought in the toilet bowl and all this. So when tenant left, no toilet bowl, no aircon. Refused. He said, I'm not taking vacant possession because you said you warranted to me in your writing.
Toilet bowl.
Toilet bowl went off, Mr. Soma.
This is the first time I heard tenant bringing a toilet bowl.
I think he had a particularly certain requirements for his buttocks, you see. So that one went off. The problem is the toilet bowl went off. The agent couldn't save his ass because end of the day they didn't. It couldn't go through because those items were not there. Agent paid out of pocket for those items.
So what should agents do in this situation?
Simple inventory list. And double check it if there's a tenant there. If the vendor, see, the problem was in that case, the agents unfortunately was at fault. Is vendor very clear in the WhatsApp said what is not the tenants. Then he gave the tenancy agreement. Now, of course, the agent, a bit of pity to him. Of course, he didn't expect toilet bowl and aircon lights out of this one. But if he had just asked the tenant, is there any of these properties or any of these items is not yours, would have saved the thing. 1.2 million.
Just that one question.
Just that one question. And it wasn't that hard because he was talking to the tenant for that 3 months or 2 months for that during the exclusive listing period. He was going every day there. He was bringing the potential buyers into the office unit. He was talking to the office manager. He had access. He just didn't do that small check.
I always use this term. Sometimes we don't have the discretion.
Yeah.
You know the situation is tenancy. We need to ask further questions to just clarify. so that we don't make a mistake. And this was a how many $1 million deal?
1.2 million.
Okay, 1.2 million exclusive. I think definitely 3%.
3%.
If 3%,
36,000 was
36,000 gone. So these are things that we must be careful. And I know there are many cases out there like this. We are losing out on a daily basis. And can you imagine in a year how many deals I bought it? So today's topic is to make sure that we don't make a mistake, so that after all your hard work, you will be able to get your commissions. Okay, let's move on to the next question. Deposit and forfeiture issues.
Yeah.
Okay, many RENs don't fully explain the rules on deposits and forfeiture. What mistakes do you see here, and how can agents avoid exposing their clients to risk?
Okay. Forfeiture for sale and purchase, especially on the offer to purchase side, actually is very standard, very straightforward.
Okay.
The mistakes that they make is making small, simple mistakes. Okay. My favorite one was this recently, Merdeka time. 14 days versus 14 working days. I think you already can see where the story is going. The vendor very clear. I need to, he got a job overseas. He needs to go. 14 days, I want to sign everything and go. Simple, fair enough. So when he said, okay, look, the offer is coming in, I don't have much time, 14 days. 14 days, okay, no problem. So agent did his job, put everything 14 days, gave to the purchaser. Purchaser said, I am from Penang. I need 14 working days to sign. Agent said, no problem, I'll get it for you 14 working days. So they sign everything, send. We didn't amend the offer to purchase. So when it went to the vendor, vendor saw 14 days, sign lah. 14th day, asking, where is this document? If not, I'm forfeiting the amount. Vendor's lawyer is, well, he has all the rights to forfeit. 14 days, well, you never pay. Vendors, the purchaser is going, hey, no, I said 14 working days, here's this one, here's that. The, what you call it, the property agent, the agency is now caught in a bind. I'm a stakeholder. I must follow the what is in the offer to purchase. Agent disappeared, cannot be contacted for that day. Now that part, of course, was unforgivable. He disappeared. He knew he made a mistake, he disappeared. But in that period, that small change, now
14 days and 14 working days.
And all that asking, the reason they asked extra also is because, Merdeka was that extra one public holiday there. In between, there was a few things going. So he needed that extra time for bank, for certain approvals and all this, whether to get with the wife, without the wife. That all is well and good. But had he just communicated that, or just added it to this one, if the vendor said, no, I can't sign, or I have to sign in absentia, or I have to sign from overseas or whatever, that can be arranged if the agent had told in advance. And they had, it wasn't 1 day or 2 days, they had 14 days notice for this. So forfeiting a deposit is a very significant step, because you've got many parties involved. If lawyers are involved, that's 5 different people you have to satisfy. But the one that is most dangerous to me is, as the agency, as a financial stakeholder, that fiduciary duty. If you release wrongly, or you deposit, or you forfeit wrongly, one, they can take you up to Bovia. And can you imagine your license being under review because one agent, one REN or one agent accidentally signs off wrongly? The whole house of cards comes tumbling. Yeah.
Okay, coming back to this, the offer letter. Is our letter or offer that we use, we love this standard, right?
Yeah.
Is it adequate?
In terms of
Would it cover if there's any changes to be made?
I think, okay, this is I know here with IQ actually has one of the better ones that we've seen. Yes, actually it is 90% of the time it is adequate, but they must fill in the right things. The 4 or 5 major mistakes, not mistakes, the major things that is missed out: loan, whether it's with loan or without, subject to loan approval, tenancy, non-tenancy, fixtures, fittings, how many days, how much the percentage. Now, actually, I think Mr. Soma, you were the one who had a good idea about instead of the usual 2% or 3%, maybe put 4% deposit. That can be factored in. But they just, by sticking too rigidly to the template, they can't move. They can't move. That's the first one. Number 2 is some like IQI, I know I've seen the tax percentage is included. Some don't have, Mr. Soma.
Some still use 6%.
Yes, that's what I was going to tell about that. 6%. Some of it had 6%, and the vendor just said, "No, I'm not paying you. I signed the appointment letter. This plus 6%. I'm paying you 6%. I'll pay you. No problem. But I'm paying you as per what I signed. That difference you pay. Happens.
Yeah.
So,
They're clever. They're clever
very
people out
clever.
there.
Yes, yes.
They would have smiled in their heart and says, "Don't know what he's doing. I signed for it."
Get it done with it. Yeah.
Okay. No. I'm of the opinion that form is very fixated.
Yeah.
So if there are any changes to be made, there's no place to make remarks or whatever. So I always felt, and I've recommended this to the practitioners, that we should have an addendum. If you have an addendum, then you can use. If you do not have an addendum, then if there are any changes, you can write it down and get both parties to agree.
I think, if I'm not mistaken, correct me if I'm wrong, I know IQI has that clause 12 or 13 where they've got that blank space. I know some other asset firms have, some don't. And you're right. I think if they just have that space to let them cancel out, put a bit of notes.
Yeah.
Let's see what they say. Yeah.
Okay. This forfeiture again, it's not part of the question, but let me go to that. The offer letter says that the vendor has the right to forfeit. So now in our form, we do not have that clause where if you don't forfeit, I don't get compensated. If I forfeit, the agency will get compensated, right? But most of the letters do not have that. If the vendor don't want to forfeit the money?
So, okay, so this is the part where it gets tricky. Can the vendor choose not to forfeit? Yes, it's their discretion to extend or not to extend and all this. So by them not forfeiting, does the agency not get their cut? Yes, they won't get their cut immediately, but in the long term they do, because as long as the deal goes through, you still get your full amount.
Okay.
So you don't have to worry about that forfeiture. Now, why is it kept with the vendor? Because end of the day, the deal responsibility goes with the vendor. Anything that doesn't go through, or if the vendor sabotages the deal, as in many offers, vendor has to pay, not the agency. Agency just keeps as stakeholder. So in terms of that forfeiture, is there any why is it that the agency doesn't have that power? I personally think that yes, let it be with the vendor, because end of the day,
That's his money.
It's his money and his consequence. Anything goes wrong, he has to pay. But if it talks about, can the agent advise? Yes, I've seen many agents who advise the vendor, and then without the vendor knowing, sometimes tells the purchaser it's been forfeited. Now that is wrong. That is, you're acting out of
the
instructions.
agent cannot say we forfeit.
Yes.
He can only suggest. The decision must come from the
vendor. Because tomorrow, if anything goes wrong, purchaser sues vendor, not the agency.
Yeah. And then the vendor will turn around and say, he is the one who advised, he is the one who forfeited. I didn't advise him. But what happens in this case? This is for interest of the negotiators out there and the agency. There is no clause in the offer letter that says, or many of the offer letters that don't say this, that when the vendor changes his mind not to sell, he will refund back the money.
Yeah.
But then there's no clause that says the vendor have to compensate the agency. How do we handle this?
If it's not in the offer to purchase, then too bad lah. Cannot claim. But most of the time, we do see quite a number of, especially the big firms and all this, they have they must pay equivalent to the deposit forfeiture. That is also the same reason why when it goes to the offer to purchase, once it's finished OTP and it's going towards the SPA side, most SPAs have the same thing, where if the vendor defaults or if the vendor chooses to abort in the SPA,
okay,
they'll have that clause. That will be negotiated. Now, usually most of the time, RENs, REs won't get involved with the SPA, but some do. Some take a bit more proactive, and they do. When they suggest this, it tends to move the deal along, because the drag their heels. They will push, and that helps in some cases, especially where maybe vendors are fielding multiple offers or looking at certain things. We have seen where it's not it's not delay. It's like I'm following the letter, but I'm being as slow as possible, as frustrating as possible to get you to terminate. We have seen that. That small clause that says the vendor may have to pay a penalty or some deposit, some damages. One, it moves them forward. Two is sometimes by the agent pushing for this, or the agent saying, look, hey, this might be coming into play, it sort of gives the vendor a different idea of, hey, I better not delay or better not do this. End of the day, of course, I advise all the agents, don't simply push the vendor because you're acting for the vendor.
Yeah.
But do advise them that this may come into play. So before you do all that, make sure you got the paperwork in order. A lot of the time, the delays are just paperwork that could have been prepared before the sale or before even the offer comes in. The moment you say you have a chat with the agent, okay, I want to make you my exclusive agent. At that point, if the agent just asks, okay, hey, Mr. Vendor, so and so, put this list of documents, please prepare. It makes the deal 100 times faster.
Yeah. Okay, one more question on this, again, on this forfeiture. Specific performance. A lot of us, not me, a lot of people do not understand that the purchaser has a right for specific performance, right? Can you just explain how this works?
Okay. Of course, Mrs. Soma, you know better than even most lawyers actually how it works. I won't this one. I'll give the simplified version is, long story short, you are forcing the the vendor to sell the property to the purchaser as per the terms of the contract. So that means if I'm buying for 1.1 or 1 million, okay, I've already paid my 10%, 100,000 paid. We're almost done. Suddenly the vendor says, oh, I don't want to, something goes wrong somewhere. A lot of SPs have the clause to say that the purchaser on their own discretion either can take back the 100,000 or I can compel, I'll pay you the 900, give me the house.
Okay.
Now that is specific performance. The con with specific performance is most of the time you need a court order to enforce it.
Okay.
Going to court, paying that extra legal fees, etc., sometimes may not be worth just taking back, or it may be more economically desirable to take the 100,000 plus whatever compensation and walk away from the deal. Because forcing them to do the sale tomorrow, once you get that court order, what if suddenly the title disappears? A lot of things can go on to make the
But
deal.
are there any cases like this that successfully has gone through?
Oh, plenty. All across the country there is. Most of the time, it's where the vendor has got himself or herself in a bad deal, and the purchaser says, I've got a good one here, or I want this property. A lot of the time, developers have done that, where they've acquired quite a number of pieces of land. One of the vendors may say, hey, he's buying here. Maybe I bought this deal, force him to jack the price up and then sell again. Oh, and then they say, hey, you cannot. They'll compel the sale, buy it one shot pieces of land. That's some of the things we've seen, especially in North.
Can you do specific performance after collecting the deposit, offer letter signed?
No, because there's no
Sales and purchase agreement. So it's only after SNP.
Because the SPA will give the right there.
Okay.
Because at the deposit, he can
But in the offer letter, we've got that clause on specific
performance. They say can, but most likely not, because you haven't gone through the other process, the checks, the consent, all the other stuff haven't done.
Okay.
It makes it a lot more difficult.
Okay. All right. Okay. Just but better understanding on this. Okay. Let's move on to the condition precedent.
Yeah.
I think you need to explain what is condition precedent, and then the question is, we often see financing clauses or state consent clauses. So what happens if agents fail to highlight the importance of these clauses, and how can a deal collapse because of it?
Okay, so from that question, there's 4 parts.
Yeah.
Take it one by one. Condition precedent, as the name says, it is a condition before the deal can continue.
Okay.
So most sales and purchases, the condition precedent that's there is the either state consent. So if it's a leasehold land, you have to get consent to transfer, consent to set to charge. Number 2, it could be financier objection. So if some properties, certain properties where the financier has a charge over the property, you may require to get their consent to proceed with the sale.
Okay.
Third could be a condition precedent where deceased property, you need order for sale. So
Okay.
you cannot, one thing I hope people realize is when someone passes away, if there is no will under Malaysian law, you must get an order from the court for the sale.
Okay.
Without this order, even though everyone agrees on all this, without this order, the land office won't register the transfer.
Okay.
So this is one of the condition precedent. Some people don't put that in the SPA, don't put that in the offer to purchase. So those are some of the condition precedent. I'll go to the consequence quickly first. The consequence of not putting that is either your days run or the sale cannot be completed. Let's take the order for sale. Everyone agreed, they wanted to proceed, they didn't get the order, the transfer from the vendor to the purchaser cannot be registered in the land office. This ding dong for more than 6 months or 9 months, and the purchaser is saying, hey, I've been taking too long. The consequence, actually, the purchaser is willing to continue. Purchaser's bank is saying, hey, you've exceeded your offer period, we want to batalkan the offer. So now the purchaser is stuck with the bag, and it was actually the vendor supposed to get. And this was not told to the vendor because vendor is a lay person, old lady. She didn't know husband's name. She just followed what everyone said. So it ended up being a sort of in limbo. And, you had to get another firm to come and rescue that.
Okay.
Same thing comes with what are the consequences not telling is a lot of the times it has to do with how long you have to wait for the vacant possession. Consent for property, let's take leasehold, let's say Selangor. A lot of times in Selangor, so I know people may be surprised, they're actually quite fast. Selangor turns around quite fast. KL sometimes takes a bit longer. Now, once you get the consent and you move, all well, all good. But what if that particular property or that particular area, there's something not right? You need to go to the Pejabat Mukim or to check something there. When that happens, that delay period, if I'm depending on me coming into this property by such and such date, or I've already given up my previous property, those are additional expenses that the purchaser ends up, or most of the time purchaser ends up just blaming, hey, what's going on? Why is it taking delay? You didn't tell me it's going to be such problem when I want to purchase the house. When I want to purchase house, very nice house, you can take tomorrow, blah, blah, blah. Now when it comes consent waiting 3, 4, 5, 7 months, how lah? Some more Johor land office, there can be some delays there. So when you're buying property in Johor, check carefully or know that in advance before going in.
You talk about time. I always advise negotiators about essence of time. So in all agreements, you have that clause, isn't it?
Yeah.
They is
Time
subject
is
to
of the
essence
essence.
of time. Can you just explain what does it mean, essence of time in an agreement, and why is it important?
Okay, the philosophical, I won't go into that. Time is of the essence. That clause just basically says that there can be no delay until and unless expressly stated in the agreement. So quote unquote delays is any additional works that were not foreseen. Example, trying to get a redemption statement or a discharge from the bank. Now, we all well-meaning, you can, as much as you try, okay, I get the property, everything, I give to the bank. Now, the bank sits on it. Usually, most SPAs have a 14-day period. We'll wait. But after that, those delays will count in favor of the purchaser. So time is of the essence is, if you don't keep within that 14 days, any days extra, it helps the purchaser. Of course, in modern contractual terms, you don't really see that clause being invoked as much. It's a problem.
Okay, all right. But okay, this reminds me of this in the offer letter, the statement included. I make the offer subject to bank loan.
Yes.
Explain that. How, I'm sure you have gone through some of these cases.
Okay. Not a lot of times, in a number of circumstances, when a purchaser is buying a property, usually either it's first purchase or usually if first purchase alone, then maybe the second purchase is with a couple. Loan, you may not be eligible for the loan automatically. Quite a number of less experienced purchasers don't check what the eligibility is. A lot of time their banker friend will say, never mind, you go and see the property, you give then and I'll check. Okay. So if you don't put subject to the loan, when you pay the deposit, tomorrow if you don't get a loan, you're still compelled to proceed with the sale. And a lot of the time, these people don't have the money to continue. They need that They were banking on that loan for the 90% or 70% whatsoever. So if you don't put it in the offer to purchase, tomorrow, even if you get a loan rejection, sorry, it proceed. If not, I forfeit your deposit. So that is subject to a loan. It means subject to getting a loan approval. Sometimes they may put subject to, if you get one rejection, it's not enough. You must get two rejections. Then only we will.
So how specific we must be in that? Because I know a lot of complication have arose because subject to bank loan, and then they say no, subject to bank loan from Maybank or subject to bank loan from public bank. That's what I thought. Now the two banks don't give, so I'm not going to pursue. Then there's a
clash.
legal issues.
Okay. When it comes to how specific, how specific you want to be is subject to parties. We leave it to that.
Okay.
But what we must advise is, if you give it generic, one loan or two loan, then it must only be, it can be any bank rejecting. You cannot say that just because Maybank said no, I don't want to go through. No, if you have two rejection and only Maybank reject, I'm sorry, onus on the purchaser to proceed. But if you are saying I'm banking or I'm relying on Maybank or public bank because of the rates or because of some offer there, then you put that in the offer to purchase. If you don't put it in the offer to purchase, then it goes in favor of the.
So be specific.
Be very specific.
Okay. All right. There's a quote, do not be wandering generality. Be a meaningful specific. Okay, let's move on to the next one. Title and ownership problem. I think this is the one major issue which a lot of agents don't understand. Okay, will, probate, administrator, and all the stuff. So when the property title has caveat,
Okay.
pending subdivision or outstanding encumbrances, what should agents know? How can missing these red flags will kill the deal later?
Okay. Registration of title, I don't want to talk too much on the probate will, because that one's quite standard.
Okay.
If the deceased's name is registered, it is on the administrator or the executor to register as sebagai wasi, sebagai petate, then only get the order for sale. Okay. Standard. The problem is sometimes the agent will be talking to the surviving spouse or to the children, and the children say, yeah, I want to sell. They will proceed exclusive appointment all under the children's name. But that's not the owner, or that's not the representative of the estate. So that first check on that. Okay. Now when we talk about the caveat, I have a good story, a quite fun one. There was this big piece of land, it's houses, not even your usual strata title, houses, where the developer's financier had put a charge on all the properties. So when they subdivided on all the property, the developer's financier is there. So say I take from Maybank, developer took from CIMB. On all of the titles, CIMB is there, even though I never took a loan from CIMB. Okay. So now when I want to sell, the encumbrance, the charge is actually the developer's charge. It makes the sale so much more difficult because you have to get the developer to pay off or to confirm that it's removed, get it removed with the land office, and then only go ahead with the sale. Or maybe you go ahead with the sale, now the purchaser has to liaise with the developer, and this ding dong delays the deal by 6-7 months. Now, what should the agent do? What should the agent check? Number one, as what everyone advised, do that Carian Rasmi or Carian Persendirian. Check. And if you see any bank there, just courtesy call or something to the vendor. Hey, I saw there's a charge here. You got a bank loan from this person or from such and such. Especially if it's just only subdivided land. If it's just only from developer came to the vendor, ask that question, because likelihood is there. If you don't do that, this is where the SPA gets dragged on. Some of them, they choose not to sign the SPA until this is resolved as a condition precedent, like what we talked. And this means you get your commission a lot later. Fees. Legal fees can always take it later. Correct.
So coming back to the subject matter of encumbrances and caveats, should an agent, a good agent, should they know whether there is a caveat on the land?
They should. If you did the Persendirian search, most 9 out of 10 times you'll see.
So you must do a search.
Yeah.
And lawyers can assist there, right?
Lawyers can assist there, yes.
How much does it cost to a search?
If it's a private search, it's only 30 ringgit.
30 ringgit. 30 ringgit do a search. So if the deal is big enough, what is 30 ringgit? You need to do that. But of course, there's this big sentiment out there. That's not my job. That's lawyer's job. But by the time you go to the lawyer, the offer is already signed and accepted, and that's where the problem arises. So please go and do a search. Let the lawyers do the search for you. Or if you got a runner, they can do the search for you. Or if you really want, you can go yourself and do the search. You can get that immediately, right? Okay. Now you don't need to go to the office. You can do online search
so
now.
depending on which like Selangor Smartbox, KL, it's got your Wilaya. So you have the tools are there, very easy to register and sign up.
So that is what makes a good REN. Okay. So this is something that you need to do. Okay. Okay. Let's look at legal capacity or parties. Okay. Have you come across cases where one party was not legally competent? This is a very, when we say that, I think a lot of them want to understand. Legally competent, example, a company without proper authorization, joint owners, not signing, etc. How does this oversight affect the contract? Or what should we be wary about this? The MD comes and says, I want to buy this shop lot. So has the MD has a right to authorize, or if it represents a company, how should you go about it?
Okay, so questions on company can be different. Sometimes if that MD is the sole owner, sole proprietor, then jalan lah.
Okay.
Now if the MD is coming in, it's a big company. The Companies Act makes very clear for Sdn Bhd there are certain rules, certain resolutions that need to be passed, certain forms that need to be complied with. Now, if they don't, even if I am the CEO, I turn up and I say, no, I'll sign and all this, it is difficult to bind the company. Why? It's because the company is a separate entity from the MD, unless they have given authorization letter. Agent, very easy to check, or REN is very easy to check. Hi, sir, fantastic, thank you, good offer. Because I noticed is a company or nominee, can we please get the appointment letter? If not, put it as such an MD or whatever that MD's name, or nominee. Then later you can transfer to the company to be the purchaser.
Okay.
That's first part. Number two, when you talk about competency, whether they are competent, the two good ones that we have is, one was like I mentioned, where the children of the deceased were signing on behalf. They have no legal right to do so. So they have no legal competency to sign. The other one was actually, it's a bit of a sad case, was slightly mentally challenged person. They had a caretaker, but the property was given to the challenged child. So the sister who was doing everything was taking care of him. I was okay, look, needs to sell the property to put him in a home. Happens. But because she signed, not him, and didn't get a guardianship or anything, deal can be made invalid. So the land office refused to register the
She's not legally
She's
competent.
not legally, so they had to go around, get certain things done. But that small change is, okay, look, if such and such is the owner, and someone else is coming as the seller or the buyer, very easy, just like how an agent would ask, what is the appointment? What is the link between A to B? I know it may be an uncomfortable question sometimes, especially, the big datos turn up and all this, may be uncomfortable, but better to ask it then. And after everything signed, just before the SPA sign, they say, tak boleh. Small question, but one that I would recommend asking.
What other things could be considered legally competent? Age, mental, people, this is the mental case. So if she's mentally affected and she's one of the child, can she be competent to sign?
She cannot, because legally that particular person did not have the mental capacity to sign. That's why they had to have a guardian. And the sister was the guardian for all effects and purposes. The only problem is it is not a legal, recognized guardian. So that part, I know it's very rare, especially in Malaysia, but something still to consider.
Rare cases, but it still happens. So I've always said this to RENs. When you go and list a property, how do you determine the legal ownership of the land? And what document do they, okay, this is a simple question. What document do they have to refer to?
number one rule in Malaysia, title above all. So as long as you do a title search, that same Persendirian we talked about, that small search would have saved him all the hassle. The only part where you cannot do that is when it's an assignment case, when there's no title for the property, then you ask for the sale and purchase agreement just to confirm, because we have seen one or two where people who have changed their names, or when they have the name on the IC is changed compared to what they previously were known. The SPA was in their old name. Sale they want to do in the new name. So you just need to get that particular. So before even you go ahead, if you've done the search, you would have seen, hey, hi, so and so, is this you? Oh, it's you, because same IC number. Okay, can we get the confirmation JPN, that particular thing? Done. Easy. But by not checking that, tomorrow when you go, if the buyer is doing a check, hey, someone else is selling, I'm not this not buyer, I don't trust the deal, I don't want to sign the offer to purchase, which is a valid thing for the purchaser to be wary about. So that small changes, that search, so important.
Please go and look at the title before you start selling.
Please, yes.
It's like your birth certificate or your IC. Okay, I always use this example. Why is it you cannot go and look at the title? Ask. Why can't you? This is another question. We do not verify the person I'm talking to in relation to the name in the title. So there's a Soma Sundram there and the title. But are you talking to Soma Sundram and who's authorizing you to sell? So I said, check the IC lah. Just look at the IC. They can't.
Okay, if in the course of the appointment or just before the appointment letter, let's put it this way, the tactful way to do it. Oh, so and so, I know you're going to sign the appointment letter just for the purposes to check this. Can I just take a copy of IC? Oh, can I see the IC just to confirm the same spelling correct or not correct? That's it, a simple check. And I know you have said it multiple times, especially even back then in MIA. I will say it again. Please get the appointment letter signed before you go and do all this extra work, because you'll be surprised how many of them are choosing not to pay. They're renegotiating after the sale. And what are you going to do? You don't have anything in writing how to proceed.
So this is not a common mistake. This is a common habit that we all take
for granted.
Lah, remeh-temeh lah, tak apa lah, So end of the day, who's losing? It's a RENs who's losing. Okay, I was at a class last weekend. There were 100 last weekend. The week before that was 160. When I ask all of them, how many of you get appointment letter signed? I think out of that, I couldn't even get 10% putting up their hands. So this habit needs to change if you really consider yourself to be a professional. Okay. Okay. Special conditions versus boiler. I got this term boilerplate clauses. What is that?
Boilerplate, I believe the term actually comes from, if you remember the old heater system, they used to change depending on how the heating system worked. So boilerplate was, they came in to say boilerplate was the template. Then you had all the other ones that changes was the, what do you call it, specification that you did for your own house.
Okay.
So anyway, when you call about boilerplate is your template lah.
Okay.
Everyone is doing a template. Now what is the problem that I see is everyone is molding or pushing the deal to fit the template rather than using the template to fit the deal. You think?
Can you repeat that?
Okay. So I've seen deals where it's straightforward. Okay, I want to buy at X price, but I want to buy the fixtures and fittings slightly higher price. But we're going to put this price on paper for tax purposes or whatever purposes. Straightforward. Agent is telling them, no, cannot. Why? Because in the form tada, it doesn't say that.
This is what you talked about earlier.
I said, you can fit that in just so simple. Take that small part, put it at the back. Job done. But that agent, I don't know why, nearly killed the deal because he refused. He said, no, my agency is like this, I must follow this. So the template is a guide. It's a guide. It's covering all the big bases.
It's a recommended form.
Correct.
That's what we use in the board. Yeah. So it is not. It's not written in what? It's not carved on stone. Yeah. So that's why I'm so excited to make sure that all the agents follow this addendum, which has been used in Australia for years. And I remember using it in my previous company, SK Brothers, I think some 20 years ago. But nobody nobody is used to it, and so they don't know how to do it.
Yes.
Such a powerful document. Okay, so the question is this: sellers sometimes insert special conditions like renovation, removals, or a short completion timeline. What are the risks in all this? So what should they do? What should we look at and make sure that it's done properly?
Okay, renovation part, like say, let's use that addendum, very powerful addendum. Renovation part, if it's put in there, it's something to comply with to make sure that it's in the sale and purchase agreement.
Okay.
With regards to the second part, which is to do with shorter period of time, as long as the agent explains to the vendor, okay, look, you're going to get your money faster, but this also means all your documents must be prepared earlier. You must give everything. You cannot delay. As long as that small explanation is done, there's no risk, because the risk, you've explained that risk. Whereas when it comes to over the top, I've seen one where it says all these particular renovations must be done at this particular way, and they didn't do. Vendor said, hey, no, I don't have to do that. The agent is not representing to me or never protect my interest. No, the agent, if the agent explained, look, the purchaser is willing to pay you X amount subject to this, you agreed, signed, then I'm sorry, the risk is with the vendor. But by not explaining, that's where the agent gets in trouble.
So if there are any special conditions, please clarify it and make sure it's written and make sure both parties are very clear.
Very clear. Put it in black and white.
No ambiguity.
No ambiguity. That's the worst thing for a deal.
Okay. All right. Foreign purchase.
Okay.
In Malaysia, foreign buyers have state restriction and minimum price thresholds. What mistakes happen when they aren't factored into the contract?
A long story short, no SPA. If it cannot be registered in the start, if you are below the threshold, no sale.
If minimum standard 1 million,
1 million.
Cannot.
If it's 950, sorry lah. Whatever you do also cannot. And you also cannot artificially inflate. Now, one thing that some people are doing is if it's a $2 million threshold, it's 1.5 million property. Sometimes they say, I put it as 2.1, willing buyer, willing seller. LHDN will question. So if there is a foreign purchaser, know which areas are going to be your areas which can sell. Just focus there. Don't try to be too clever, because what happens is you're putting too much time and energy in something which LHDN is well aware of. The market forces or certain regulatory bodies are looking out for where these foreigners are wanting to purchase. So if you're, why you want to fight there? There's no point, because they will stop the deal.
Even if it goes somehow or other, it goes through. If tomorrow they have to find out,
then
there's a legal issue. They'll come back after you,
because they'll say you told me it can be done or cannot be done.
Very interestingly, there's this thing about this word called adjudication.
Okay.
All right. Can you explain to them? You pay $1, right?
Yeah.
Adjudication, right? Can you just explain that part? What's that adjudication? Why is that done?
Okay. So the adjudication, actually, there's two parts. One, there's adjudication when it comes to that specific if they're going through tribunal, that's that adjudication.
Okay, that's a different
9 out of 10 times you're not dealing with that. Adjudication for conveyancing is when we submit the documents to LHDN.
Okay.
The LHDN adjudicates, checks what's the total value, and then issues the stamp.
Would that be the stamp office?
Stamp office, yes.
Okay.
Sorry, stamp office. Thank you so much, Soma. So when the stamp office does that, that process of calculating the valuation of the contract versus the valuation of the property, that is called adjudication. So now we all use it as a short form to say, I'm submitting to stamp office, it's adjudicated. It's not. The adjudication is done by the stamp office, not done by lawyers.
So that process, that $1 you pay for that, that is where they will check the price, and if it doesn't make sense,
they will ask questions, or they will tell
or they refer to the valuation department, whatever. Then they say something is wrong here,
and this is where your deal gets really dragged on, because once it goes to the valuation part of the stamp office, that is where they have full discretion. Let's not play around. They have full discretion. And if they have full discretion, they are going to check everything, and they are going to err on the side of caution. If it looks funny, I batal first. You come and explain to me, which is their right. So why go there in the first place? Check.
Has this happened with you before?
Quite a few times. Not out of anyone's mistake or anything. Sometimes, for example, we have one seller. She was selling undervalue because she wanted to just get rid of the property. From the commercial side, you sure? You confirm? You understand? Yeah, go. LHN said, no, why? What's going on? There's something fishy here. We have to go and give one whole letter so that husband has passed away, lah, this wants to go away, lah, children are overseas, this is this. Then only they come. So if you know that something is not going to match market value, it's going to be either too high or too low, for those cases, all right, let's already plan ahead. Let's have those letters ready, the SD ready, signed, to a firm, you're done, deal goes through.
Okay, at least now they know what is adjudication. In fact, for information of the audience, that is where NAPIC picks up the data
Yes.
on the transaction, and that's how they get you. So that's why every transaction, this happens. Okay, best practice and protection. Last question.
Okay.
It's before. Finally, what practical advice would you give RENs to spot these red flags before the deal collapses?
Three big ones, simple ones. First one, as we talked to death, Charian, just go and do a lens search. If it's applicable, do the lens search. It'll save you lots of time in the future. Number two is not do your homework, but just have some small checks. Have your own checks and balances that you have found over the years, or maybe some things that, or if you don't know, ask someone more senior, more experienced. Simple things like check the street name, go drive by the property. You'll be surprised, a lot of RENs who've joined the market after COVID are relying on Google Street View as their check, which is okay. It's a smart way to save money, but how do you know it's correct or not? How do you know the condition of the property?
Okay.
So that's just drive by. And the third one is, and I can't believe you have to say this, meet the vendor. Go when you get your commission your appointment letter, exclusive appointment or appointment letter, go and see the vendor and get it signed. So many times people are doing electronic signature, you don't know whether it's correct or not.
You know, I want to say this very openly to everybody. It's very embarrassing for a lawyer to come and tell me, please, RENs, go and meet the vendor. This is something basic that we have taught in NCC, that the first thing you must do, don't depend on your handphone and WhatsApp. And of course, what is that? Confirm. You know, this wrong address. There is a case study where a REN went and to do help the purchaser on auction property. So he went and auction, and this guy went and taking the advice of the REN, went and auction and took the property. Later found out it's a wrong property. The property, one is along Jalan Medan Lumba Kuda, and one is Jalan Lumba Kuda.
I see.
Medan Lumba Kuda and Jalan Lumba Kuda. So he went and bought from the wrong address. So this happens. So okay, so let's summarize from what you have said. The three, apart from what you said, check the details before anything. Always make sure, check your title, check whatever that they want, what are the things that comes with the property, what don't come, what are the features,
the tenancy,
all that stuff, okay? The tenancies are one of those that they really do not follow through in detail. Thanks for advising that. What's the timeline? Timeline is also important.
Very important.
Okay, deadlines in essence of time.
Especially if there's banks. Banks are very particular about time, Mr. Soma. 3 months is 3 months. Whether your deal is 6 months doesn't matter. Their timeline comes first.
And then most importantly, you must always protect your client as a professional. We are an act. The reason is because we must protect our client. And when you protect your client, you protect yourself. So that's it. That's another 3 points. So whatever Ananda was saying was about making sure that you don't have any pitfalls. Watch the red flags. Don't do the pitfalls. So end of the day, you're able to get your fees. And then from the fee, you get your commission. Okay? So our role is not just to close deals. It is to close them right. Oh, there's a question on the Facebook. I don't have the question because my it's not working. What's the question? Never mind, you can voice over. My computer hang.
Okay. Again, which re-emphasizes sometimes technology.
How can buyers protect themselves from possible delays in property readiness, as in if the construction takes more time than planned? Is there anything we should know?
Oh, very good question. How do you protect yourself? The developer delays. Now, this deals with new property, housing developers. Now, you cannot 100% protect yourself. It's impossible. But what is built into the HDA, the contract is, if there is any delays, you're going to be paid LAD, assessed damages. So these particular damages is already inbuilt, so you'll be compensated. This incentivizes the developer to push as fast as they can. Now, we have seen because of COVID, KPKT has given certain extensions. So again, if you ask me how is the best way to protect everything, impossible. But there is already inbuilt insurance against delays. And also remember, if you're taking a loan for development and all this, they are paying in stages. So you won't have to pay that full loan sum until that particular payout is done.
So in the case of, let's say, the secondary market, where there are conditions like that, they are renovating the house is going to be completed in the next 3 months, but there's a delay.
Yeah.
So what should we do in that case? Because you have drafted the agreement, right?
Right.
What would you recommend that we do?
Okay. Before even going to that drafting agreement, the first thing I would do is anyone who's buying secondary market, this getting ready stage, first thing is think very carefully, do you have an appetite for any delays? Before even going there, can you or are you willing to wait? If you are not, this property is not for you. Okay. Number 2 is in the agreement, how do you protect yourself is have some of these back-to-back clauses where if anything delays in the first one, whatever payout the first guy is supposed to get, you're going to get. Number 3 is you can always go, not always there, but in most cases where there's development, you can always go to see what the development stage is. And then you have a check with the principal SPA, what the vendor has. So if you see, hey, this is supposed to be stage 4, they're still in stage 3. You know already, before even you put pen to paper, hey, there's some delay here. If you see that it's on time, or if you check or you chat with certain people and you say, hey, looks like it's going to be okay, go ahead. Number 3, most of these newer residential properties, they have these WhatsApp groups, or the residents or people who are waiting or some problem is, or no problem, also they'll have a WhatsApp group or Facebook groups. Join them, ask, hey, are you guys, is everything okay, or is things going to plan, etc. They'll be able to tell you, and that's how you would be able to check in advance. Aside from that, unfortunately, you do not have the information the developer has, which is they will know the timetable, they will know whether it's going to meet or not going to meet, or what's the mitigation that they're doing. That information is just not available to the buyer.
This is something we are not really very sure, but you need to be on the ground. You need to know what's happening. Prepare yourself for the worst. Or in the event if there's a delay, then you make sure that there are clauses in the agreement to either get yourself compensated or any escape clauses that we can put it in. So that's advice we can give you. So with that, as I said just now, our role is not just to close deals, take the commission and run. We are going to be there long in the profession. We are going to do this for a long time. So it's very important that do it correctly. So thank you, Ananda, for coming. It's a pleasure. You're given a different aura to hold this, because whenever I sit with senior lawyers, the energy is different. It looks very intimidating with you. I'm very comfortable to do this. So hopefully one of these days we might maybe talk on another subject matter. So please go and help all our RENs out there with all these issues. And I want to thank you once again for coming on behalf of IQI. I've said this, but many are not aware. This is not, this show is sponsored by IQI because we believe that we want to contribute back to the profession, because this is actually targeting our RENs. And also the public who are watching, some of these can help you, because as a house buyer or a vendor, you will understand the workings of agents. So you also will be aware. So you need to also cooperate whenever you want to sell a property. Please show them a copy of the title, be cooperative, show them your IC. And then if they don't ask you, ask them why the hell you don't ask this, scold them if you can, so that we all can grow together and the profession will be able to do better. So with that, I want to thank all of you. Next month, I've not confirmed the program, but I would like to talk about the REN network, the real estate negotiators network that has been formed in MIA. This is especially for rents. Who are they? What are they doing? How are they supposed to have rents? So I'm trying to get them next month. We will advise you, so please take note. My timeline is always not fixed on last Friday, although that's the date that we have set, because sometimes holidays come, sometimes the team is not available, sometimes I'm not available, and so when all this happens, we just check the diary. Today's Monday.
Yeah.
You're not supposed to have this
Monday
today,
to Friday.
but nevertheless, thank you very much for coming in and participating, and please spread the word around that there is such a program, the only live show on real estate matters. So with that, I want to thank all of you and thank my team. Thank everybody, including you, Ananda, once again.
Thanks.
Please send my regards to your mom.
Yes, will do.
I think the whole team is watching. Okay, thank you.
Thank you.
All the best.